of the vehicle, and they didn't have a warrant in effect. And they used it to follow him mechanically for 28 days. There was testimony at trial that much of the time the the agents really weren't following it. They just had a recording. And at trial, there were about 3,000 pages of moment-by-moment records of the location, every place Antoine had gone. So they were able to do a timeline. They had a timeline, evidence at the trial, to show Antoine's proximity to the suspected stash house, proximity to handoffs where drugs were supposedly exchanged between himself and and certain informants and defendants who were also indicted in the case. The judge ruled at trial that the evidence could be admitted, and I was appointed to handle Mr. Jones' case on appeal by the U.S. Court of Appeals for the D.C. Circuit. And I argued to the D.C. Circuit that back in, I can't even remember, so long ago, I argued to the D.C. Circuit that there were two things wrong with that. I said, first of all, that it was a seizure of Mr. Jones' vehicle. And a seizure because they put the device on the car, and although it didn't interfere with his use of the vehicle, it certainly allowed the government to get information that they couldn't have gotten had they not put it on the car, because nobody was following him in real time on the street. I mean, it's okay. The government can use its resources to follow you on the street if it wants to. That's not a Fourth Amendment violation. The government can follow you 24/7 on the street if it wants to. It can post people across the street to watch your doings. That's not a Fourth Amendment violation. But we said in the case of putting something on his vehicle without his knowledge, consent, and permission, and without authorization from a judge, that was a violation of the seizure clause of the Fourth Amendment, and it was also a violation of the unreasonable search clause of the Fourth Amendment. We had 15 minutes aside to argue, and I had a co-defendant, so I had 7.5 minutes to argue the case in the D.C. Circuit, except that they had me up there for 45 minutes, and I remember when I sat down, I felt like a piece of rejected meat in a Mexican butcher shop. I didn't think anybody was going to buy this argument. And then the AUSA, Assistant U.S. Attorney, got up smoking his victory cigar, and within about 5 minutes, the panel had him looking like a piece of rejected meat. We got a decision from the panel about a year later. I have it from a friend of mine that the author of the opinion took I think about 20 drafts. Whether that's true or not, I don't know. I can only say that the opinion itself is a masterpiece of writing. I should explain the panel. One could not have asked for a more philosophically diverse panel. I had the Chief Judge of the D.C. Circuit, then Chief Judge Douglas Ginsburg, who was a libertarian by philosophy. I had David Tatel, literally on my left, who was a Clinton appointee and fairly liberal. And then on the right was a recent appointee from Utah, a very conservative George W. Bush appointee named Thomas Griffith. And they coalesced in a unanimous opinion from the D.C. Circuit that said this was wrong, but it was an unreasonable search. They didn't talk about the seizure issue. The government then sought rehearing en banc by the full D.C. Circuit, which turned them down 5-4. And then the government had to decide whether to take the case to the Supreme Court. And that was actually very unusual, because they asked the Supreme Court for 4 extensions of time while they were trying to decide whether to take it up to the Supreme Court. The primary reason they wanted the Supreme Court to take it was that the D.C. Circuit opinion conflicted with opinions from several other federal appellate courts that had held to the contrary, but said it was perfectly copacetic to put GPS devices on people's car, applying the reasoning of the old Knotts and Caro cases, which I had said in my brief, that's just wrong. You people aren't reading this correctly, that Knotts and Caro do not stand for the proposition that the police have the right to put one of these devices on your car without a warrant, without your knowledge and your consent, and remotely track you mechanically, constantly over a long period of time, or actually in any way, for any period of time. Well, the government took 4 extensions of time, and along the way, they were kind enough to give me an audience before the Solicitor General's office, which I thought was going to be 3 people. And I walked in there expecting to talk to 3 people, and lo and behold, I was in a room with about 35 people who were representatives of every law enforcement agency under the sun, and some whose names and acronym I hadn't even heard of. And I said to them, listen, folks, if you take this case, you're going to ignite a firestorm, because this is not going to look good for the Obama administration, the government, which prides itself on believing in some civil rights. I don't think it's going to look good in terms of what the people on the left and the right are going to say. It's an infringement on people's rights. And while I don't profess to be a very strong civil liberties supporter, I certainly believe in the Fourth Amendment every inch of the way. And you people, you just shouldn't be pushing this envelope. But they didn't want to listen. They took it up to the Supreme Court. And the Supreme Court took the case on June 27th of last year. They took it on an accelerated basis. And because I think the reason they did that, they wanted to give law enforcement relatively quick guidance. We argued 2 things in the Supreme Court. The government had asked for the Supreme Court to take it on one issue, the issue of whether or not the placement and the monitoring was an illegal search. And we asked the Supreme Court we asked them 2 things. We said, look, don't take it at all. Let this time and let this thing percolate through the system. Let the other courts of appeals grapple with the implications of our decision. But if you're going to take it, there's another issue you ought to address, which is whether or not it's a violation of the seizure clause to put this on somebody's vehicle without their knowledge or consent or without a warrant in the first place. And the Supreme Court said, okay, we'll take both questions. So then the government went and filed its brief in August, and we filed our opposition in September. And we argued 2 things. We said, first of all, that at common law, and by common law I mean 1791, the time the Fourth Amendment was adopted, that one of the bedrocks that principles was, for lack of a better term, it's your property, stupid. The government can't interfere with it. It can't take your property and use it to get to trespass on your property and get information that it couldn't otherwise get. One of the things we said, that as a matter of common sense, nobody really expects his or her next door neighbor to put one of these devices on the car to track them around, so why should the government be allowed to do it? And we also argued that this was a violation of, this is an unreasonable search for the government to follow you for any length of time by putting one of these devices on your car. In early October, we were blessed with support with amicus briefs from 12 different amicus briefs from EPIC, the Electronic Privacy Information Center, from the Center for Technology, Democracy and Technology, and the Electronic Frontier Foundation, from the Rutherford Foundation, which is a fairly conservative group, from the Libertarians and the gun owners, filed a brief. There was an elegant brief filed by the Constitution Project and the ACLU, the National Association of Criminal Defense Lawyers, and several other organizations. And what happened next was I argued the case in the Supreme Court on November 8th. And I remember the first question out of the gate of the government, which went first, was a question that Chief Justice Roberts asked Michael Dreeben, who is a first-rate lawyer, a fellow Duke Law School alum, and I asked Mike, well, can you do this to us without a warrant? And Michael gulped and said, yes. And I passed a little note to Walter Dellinger, who had been my mainstay and my bedrock throughout this, for the Supreme Court process. I slipped him a little post-it and said, I don't really think I need to stand up and argue. I was being facetious, but he said, not so fast. So the justices worked Michael over pretty well, and then I got up and they worked me over pretty well. And the justice who gave me the hardest time, the 2 justices who gave me the hardest times in terms of posing really tough, well thought out questions with Justice Scalia and Justice Alito. And we got a decision last Monday. It was a unanimous decision. The government accepted both our theories, although with a twist. First, they said, they didn't say it was a seizure, but they said that it was a violation of the Fourth Amendment. There was five justices, an opinion written by Justice Scalia and the Chief Justice, Justice Thomas, And one other justice, and joined by Justice Sotomayor, held that it was a violation of the Fourth Amendment for the government to put one of these devices on Mr. Jones' car without a warrant. And they went back to the trespass theory of 1791, and they analogized it to something we pointed out in our brief and at oral argument. It's the same as having a constable, having an uninvited FBI agent in the trunk of your car. That's not what that's interference with your car. That's a trespass. So we had 5 justices that agreed with that theory. And then there were 4 justices, a concurring opinion written by Justice Alito, and again joined by Justice Sotomayor, that said, well, not only that, but it was an unreasonable search and seizure for such long-term surveillance, that society is prepared to say that the use of GPS devices for such a long period of time infringes on people's reasonable expectation of privacy, because the Fourth Amendment was created to prevent abuse of government power and to give people a right of security, to make sure that there would be somebody balancing people's interest in privacy and the government's interest in enforcing the law. To balance that would be a judge to decide whether or not a warrant should issue before the government could make an intrusion into people's lives. So we had two sets of opinions. Ultimately, it was unanimous. Both our theories were adopted, and that leads us to the question of what's next in this brave new world. And I think Marsh and I and Hania certainly would welcome any questions you have. I guess my first observation that I would throw out is that we all know now that law enforcement doesn't have any right to put one of these electronic devices on your car, your briefcase, put it on top of the heel of your shoe, because with nanotechnology, Lord knows what's going to happen without a warrant. The real question is not so much, to me, the property rights argument, but what are the implications of the concurring opinion that Justice Alito issued, joined by Justice Sotomayor, which, under some circumstances, long-term surveillance by these sorts of devices has Fourth Amendment implications. There are a lot of things going to be left open. I'll give you an example. Is it okay for the government to follow you mechanically with some sort of a device that is not placed on your car for 2 days? Is that okay? These are questions that are going to have to be sorted out in the courts for years to come. There are all sorts of new technologies that are coming into effect: drone technology, infrared sensing technology. One of the things Marsh and I were talking about, and again, this is really a very impromptu remark on my part, was what about cloud computing of it? Do they have the right to go to the folk that store data and without your knowledge and consent, without a warrant, and get that information? This is the whole brave new world we're now walking into. The one nice thing about the Jones opinion is that it has brought the justices kicking and screaming into the 21st century. It's certainly the first case that involves really new technology in the Fourth Amendment that arose in the criminal context.
And just to add a little bit, Hanny and I, we both had the pleasure of watching Steve argue before the Supreme Court. And before that argument, a lot of people asked me, what do you think is going to happen? And I said, I don't know. We have actually a lot of new justices right now. I could predict where they're coming from, but I don't feel like I have much of a sense. I know there are some conservative ones, and I know there are some more liberal ones, and then there are some that are just wild cards to me. I have no idea. And I was amazed at the oral argument how many justices had all these questions that suggested that they really understood the technology and how it worked, and that they were really grappling with the bigger implications in other areas of technology. And I remember, I think it was Justice Alito who was asking about reasonable expectation of privacy, and he was saying, in an age where we have Facebook and we all have all these friends and we put stuff out there every day, what does that mean for reasonable expectation of privacy and what society is prepared to recognize as reasonable? Does this mean that this just erodes away? And I was just like, wow, that's a really tough question, but that's a really good question too. But they get it, And I think that's really exciting and really heartening. And from my perspective, since the 60s, the test has been whether you have a reasonable expectation of privacy. That's been the test. And in Scalia's majority opinion, he says, yes, it is that, but duh, of course, it's about trespass too. That's what we've always said. And it's funny because he sort of treats it like that's always been the rule. Didn't you all know that? That's always been the rule. That's always been the rule, right? And then the concurring opinions, the one from Alito and from Sotomayor, I mean, it's clear that like the rest of those justices didn't realize that was the rule. And Justice Alito made clear that he still doesn't think that should be the rule. He doesn't think it should be about trespass at all. It should just be about reasonable expectation of privacy. But at this point, it's pretty clear that the majority of the Supreme Court thinks that it is a question of trespass. In addition, it is a question of whether you have a reasonable expectation of privacy. And if you violate either of those tests, then it's unconstitutional. So I think that, frankly, the Fourth Amendment is broader now than it's been in decades. And that's really awesome and really, really exciting. Do you want to add anything?
Yeah, just real briefly, I think what's another thing that's very interesting, because there was some discussion in the concurring opinions that, well, let's be realistic, all this surveillance happened in 2006. Well, today in 2012, the government doesn't need to go snooping behind cars and install tracking devices on mufflers, right? It can do it through your cell phone. It can do it through any other means, OnStar, for example. So the majority opinion that Justice Scalia wrote does not address that issue at all and basically says, well, we don't have to decide that, so we'll leave that for another day. And he doesn't really show his cards. But both Justice Sotomayor in her concurring opinion and Justice Alito in his concurring opinion highlight this. And Justice Sotomayor especially goes to great length to say this is a problem, because the reality is the government can do this without an actual trespass. We are going to have to address this in the future. And what I think is really encouraging for us civil libertarians is for a long time the government has argued in getting like cell site tracking data, for example, that we don't need a warrant because this is stuff you've turned over to your cell phone provider, and once you've turned it over to a third party, you don't have any right of privacy in it. And that's been the law for a long time. And Justice Sotomayor, for the first time really to have the Supreme Court and justice on the Supreme Court in an opinion, kind of call out that theory and say this theory, which is based on a case from the 70s that dealt with bank records, basically Justice Sotomayor said, this does not work in the 21st century, and it's time to call that doctrine into question. And, once that issue comes up before the court, we know we have, hopefully some good, we're going to be able to get some traction there, and that'll do a lot to really kind of hopefully limit the government's ability to engage in this type of warrantless, trespassless surveillance. Justice Alito, in his concurring opinion, which was signed on by three other justices, also highlights this point, and he basically says it's time for Congress to enact protection on this type of data. So I think across the board, all 9 justices realize that this type of behavior by the government is unacceptable, and it's problematic, and it's uncomfortable. They all kind of differ on how they get there, but this is a really, really encouraging sign, and it's going to be very useful in the fights to come regarding cell site tracking data or other types of devices and technology that captures people's movements without the government actually physically placing something on a person or on a piece of property.
Yep. So let's throw it open. I mean, what do you guys want to talk about? Yep.
So, as far as the third-party doctrine goes, where does the postal tampering laws, how would they fit in with that? Because you put something in an envelope, seal that envelope, and put it in the mail, they're not supposed to tamper with it, they're not supposed to make it without a warrant, correct? So how is that going to be different for a packet that I'm sending over the airways, or that I've sent through the cell phone, the cell site?
So there's actually, just like there are laws and regulations that govern what the government can look at in mail, there's actually a totally separate statutory framework that regulates how the government can look at electronic information. and when and whether and under what circumstances third-party service providers can disclose records of communications and subscriber information and other data to third parties, including the government. And so that's kind of all taken care of by statute already. It's a very complicated scheme, and it was enacted in 1986, and it's never been significantly overhauled or updated, and there's a big push right now to update those laws to make them more consistent with technology as it exists today. This particular opinion, the Jones opinion, is all about the Fourth Amendment. And it doesn't really get into the statutory scheme that protects electronic data. And one of the big questions is, to what extent does the Fourth Amendment offer protection for that kind of information above and beyond, or in addition to the laws that are already in place? And so that's kind of one of the big situations. So just to be clear, in terms of electronic data that you transmit, it's already protected by statutes, and it's taken care of, it's done. One of the bigger questions is, from a Fourth Amendment perspective, what kind of protections do you have there?
On this, I'm similar enough in sort of a side channel that there have been a lot of talks here about RFID, near-field communications, Bluetooth, things where there are radio signal tagging and identifying fingerprint. Where would this fit in with those sorts of laws where they set up a sensor network and they're able to track somebody via that? Would that fall in the same wiretap laws, or would that fall more into the search and seizure?
Who's they? The government?
The government.
So under your hypothetical, basically the question is, can the government set up like a sensor network to track you?
Yes.
And they would track you how?
Via
Automated license plate readers are how they're doing it.
no. I mean, a license plate is there specifically to identify you. I'm talking about the signal that your cell phone puts off when you're not using it.
Ah, yeah, that's interesting. Yeah, it's like cell site tracking.
So, if I could answer this, I think here's where it lies. There's the Fourth Amendment is like this general overarching thing that protects you, and it says you can't be subject to an unreasonable search or seizure. It has to.
And also, like, the government can't pass laws to take that away from you. It's a very fundamental thing. You have those rights. Boom.
So then the question, without a warrant, so then the question becomes, what is a search or what is a seizure? And in the field of the technology you're talking about, there have been arguments made that those type of signals being emanated, if the government goes to obtain them, is not a search under the Fourth Amendment. And if it's not a search under the Fourth Amendment, then no warrant's required and the government can get it. Now, that's one part of the equation. The second part of it is, despite leaving the Fourth Amendment to the side for a second, there's also a set of federal statutes. It's called the Electronic Communications and Privacy Act, or ECPA, that basically says, okay, for this type of signal or content that the government wants to get, you have to meet this legal standard to obtain this information. So for example, if you want to get a wiretap and actually tape record, if the government wants to get a wiretap to record someone's phone conversation, there's a legal standard they have to meet. It's not the same as a search warrant standard. It's different. And the protection you have under ECPA depends on what it is the government wants to get. So if they want to get the content of your phone call, one standard applies. If they want to get the cell site tracking data when you're walking down the street on Connecticut Avenue and you're on Verizon and you're connecting to one Verizon tower and then you're connecting to another Verizon tower as you walk further down the street, there's a different standard that applies. And right now, there is a fight in the courts, and it's something that EFF has been involved in, where we're trying to convince judges that that type of information is a search, and since it's a search, it's protected by the Fourth Amendment, and therefore a warrant is the only legal way to get that information. The government does not take that position, obviously. And so the answer to your question, I think, finally getting back to it, is that we're fighting it right now. What the government has to show to get it. We're arguing it has to be a warrant. For a long time, the courts said no warrants required, and they relied very heavily on the third-party doctrine. You turn these records over to Verizon yourself. That's on you. But now, armed with Jones, we have a good argument now that, hey, this is, at least Justice Sotomayor doesn't think that that's correct. And it's, we're hopeful that Justice Alito, based on what he said, can also come that way. So that issue is going to work its way up the courts eventually, and now we've got another great piece of ammunition in Jones.
Wasn't there also a ruling about infrared signatures on houses and growing marijuana?
Yes, that's Kylo, and that's a case that says because the signal went into the house, that was a Fourth Amendment search, and it was unconstitutional for the police to do that. Now, there's been distinctions made between what you disclose out in public. So like if the government is capturing cell site tracking records based on you walking down the street, they're going to argue, hey, no warrant required, you're out in public and the third party doctrine applies. With respect to like if you're using your cell phone at home, there's different arguments you can make, but the government has consistently argued if you disclose something to a third party, there's no Fourth Amendment protection there.
So just to bring it back to the other hypothetical, so assuming for a minute that there's no personal property involved or no driveway, and there's no it's based on completely public data, right? So this idea of using a sensor network or camera network of that the government already monitors for traffic violations, using that to monitor you for some long period of time. Do we have any indication of whether or not which way we would go?
I think it's just totally open. I think in a situation like that, this trespass prong doesn't apply, right? So the question becomes, does it invade a reasonable expectation of privacy? In public, right. And so I think that it comes down to the question of whether a judge would say that we have a reasonable expectation of privacy in that circumstance. And I think it could go either way. I think it's quite clear that all of the justices in the Supreme Court agree that something that doesn't involve a physical trespass can certainly still violate reasonable expectation of privacy, but it all comes down to whether or not society has such an expectation or not. And one of the things in the Alito concurrence that's very interesting is he talks about how, given new technologies and our tendency now to put more data out there, we likely are going to have changing expectations of privacy as a society. And for that reason, he thinks it's very important for Congress to enact protections where it finds appropriate to protect these interests. Because I think that he feels like society's reasonable expectation of privacy is only going to erode and erode and erode. And so if we leave it to the courts to just decide these on a case-by-case basis, he worries it's not going to go well. And I think that it's an interesting thing to note.
If I could, I want sort of back up something that Jennifer just said. In 1973, 72, I think actually it was, the Supreme Court dealt with domestic wiretapping during the reign of the late unlamented King Richard Nixon. And they held that the president didn't have the authority to do domestic warrantless wiretapping. But they said that what should happen was Congress really ought to address this. And lo and behold, pressure was put on Congress. And within a couple of years, a fairly comprehensive statute regulating for that day and age electronic technology was enacted. And if I were to do anything in these remarks other than this, I'd be bereft. I would urge each of you to contact your Congress member, your senator, and say, listen, I'm in your business, your field, and what are you folks doing about privacy in this electronic age? Because not you, I am here to tell you that I can't give you any certainty that the government can't access your Facebook account at will. I think they can, quite frankly. I think if a lot of people would be surprised by that. I'm not troubled under current Fourth Amendment law with the idea if you post something on Facebook that the government can access to without a warrant. Now, if you want to change that, I mean, it begins with you. This is, after all, a democracy. And while I personally have no great faith in Congress to do much of anything, in this Congress, and this Congress in particular, maybe things will change. I mean, certainly Congress has got to be responsive to privacy concerns in an electronic age, and I would just simply suggest to you, you think about going out and meeting your Congress members saying, you know, what are you going to do about this?
Is it clear what legal framework applies to data and voice services like Google Voice, Magic Jack, that kind of thing? Do they fall under classic wiretap because of phone calls, or do they fall under third-party documents because they're data?
Well, under the Electronic Communications Privacy Act, I think they're pretty clearly protected as electronic communications. So I think Wiretap Act law would apply. And as a general matter, if voice communications were to be intercepted, the government would need a warrant. And I've never seen a situation yet where the government has argued that because you use a third-party service to complete the call or complete the communication, that the third-party doctrine applies. And in fact, I think it wouldn't fly. I mean, and that isn't even a matter of developments in technology. I mean, think about it. Phone companies were always necessary to complete calls, right? The third-party doctrine is really kind of more about what happens when you give information to some company and they're holding it. So it's like records mostly. Although I think, records of communications, I mean, for example, email, records of email in a third party's possession, there could be some argument there, perhaps, that the third party doctrine applies. But it really hasn't been about communications, that are being transmitted. That seems to be much more a Wiretap Act sort of a situation. Voicemail? Voicemail is, it's also part of the Electronic Communications Privacy Act. That's covered there.
Yeah, communications. Communications.
It's covered there. I would like to try to avoid getting into ECPA very much because it's extremely complicated and wonky, and I think it's going to go downhill very quickly. If you have particular things you'd like to ask about, by all means come and talk to us later, but I think it might start to not be terribly interesting as a discussion. Mm-hmm.
I'll say that shortly after the oral arguments, I went online and actually listened to the arguments long before the decision came out back in November. And it's something I just want to encourage everybody to listen to, in particular for the sake of what you were saying about the justices and the questions they asked and things that they said, especially in revisiting the idea of what a reasonable expectation of privacy is.
Yeah.
So it's not much of a question, but listen to it because it was a good series of oral arguments. It posed a lot of questions and it left a lot of conjecture from the justices that weren't directly questions, but gave an idea of where the court might do things.
Yeah, I agree. It's very interesting to listen to. And, I've listened to a lot of Supreme Court oral arguments in my day, and a lot of them are really boring, and you zone out, and they're not very fun. And this one I thought was just fascinating. Lots of really interesting questions, a lot of really hard questions. And again, I thought it was really heartening to get the sense that the justices take this seriously, and they actually really do understand the challenges posed by new technologies. The fear always is that they just don't really understand. They just don't get it. But I felt like they understand what they need to understand.
A lot of the Supreme Court oral argument is really more justices talking to one another, and the lawyers are simply there to answer questions and hypotheticals. And what you see, what's really fascinating about it, you can listen to it, I think it's at www.oyezproject.com, where you can read the oral argument. But the purpose of an oral argument, it's a lot different than a federal court of appeals argument. You're really watching 9 very bright people from a wide ideological spectrum talking to one another. That's what's going on there. It's subliminal, but it's a public discourse. You're getting an insight into their minds. But courts are very slow to move, and they move incrementally. The law just doesn't move quickly. And this is technology, and it does move quickly, which is why Justice Alito could not have been more clear in his opinion of the need for Congress to do something.
The cops may be a little bit slow, but the lawyers certainly aren't. Is there any reason given ever for why they didn't do it right the first time, to go and get another search warrant and move the warrant from Baltimore, from Maryland into the district?
She wants to know. She wants to know if the government ever gave a reason for not doing it right, not getting a warrant after the first one expired.
They never did, or my discussions with trial counsel were really more speculation, because it wasn't brought out in the record below, but the thought was that they believed that the Knotts and the Caro decision from the early 80s governed this situation. And our position was that this was nowhere close to Knotts or Caro, because, again, they put the device on Jones' vehicle. And in Knotts and Caro, the device had gotten into the vehicle through a third-party informant. So if you're dealing with a third-party informant or a government agent, you're doing that at your own risk. That's not going to change. And let me not confuse you with third-party doctrine and third-party informant, so that we're all very clear. It's always been the law, and it's not going to change, that you deal with other people at your own risk. If you're a government agent and I deal with you and you turn me in, that's my problem. What Marcia and I have been, and Hunter and I are referring to when we talk about third-party doctrine, that's talking about things like telephone records, bank records, things like that. And at first blush, it may instinctively seem to you, what's the government doing getting that information of mine about a warrant? But the Supreme Court has consistently held that that information is something you voluntarily turning over to third parties, even though you have to do it. Who can operate without a bank account? Who can operate without a telephone? And that's a business record that telephone company employees access, bank employees access. Now, whether the law is going to change, as Justice Sotomayor suggested it should, I play poker on a fairly regular basis, and I wouldn't put my last dollar that it's going to change that fast. I agree with her, but I just don't see the Supreme Court changing the third-party doctrine that anytime soon. So, again, I don't want to sound like a broken record. Call your member of Congress and say, what are you doing about this?
So it sounds like in the end the Fourth Amendment won here, but was there anything, I heard early on in your words, the word time and the length of time that this occurred. Is there any opinion or impression that perhaps if this was a shorter duration, that this might have been a different decision? And was there any, two-part question here, and then I'll wait for your response. Is there any indication that there may have been something in the chain of custody or the infrastructure, the way it was implemented in this third party, being involved with the tracking and whatnot, that being a new technology, was there any question as to the validity of that, the way that data was transported ultimately?
So I want to take the last part of your question first. Now, it's a little bit confusing that the third-party doctrine came up here, because it actually is not applicable to the circumstances of this case. You know, there's no question here. The government didn't argue here that the third-party doctrine won them the case here. It came up here just because Justice Sotomayor just kind of out of nowhere was just like, and you know what? Third-party doctrine is in my sights. But it really was a bit of a non sequitur. So just to be clear, you know, the third-party doctrine really doesn't come into the warrantless GPS tracking debate, I would say. I mean, this is a situation where the government planted a device on a car and they were directly collecting that information themselves, and there wasn't a middleman. So it's just kind of, for purposes of Jones, while it did come up, because one of the justices wanted to make clear that it was something that she found very problematic, there was never a question that the third-party doctrine would excuse the government's behavior here, all right?
But then there was no question of the chain of custody from how that data was gathered and processed?
Nope.
Okay.
The government was getting it directly. Now, for the second part of your question, in the majority opinion from Scalia, that opinion basically says, yeah, it's possible that tracking somebody with a GPS device over time might violate the reasonable expectation of privacy test. But we don't need to get there because the government loses on the trespass part of it. So, who knows? Could go either way. No real opinion. He flags that it could violate it. Now, Alito's concurrence says, basically, if it were up to us, we think this violated the cat's reasonable expectation of privacy test. And this was tracking a person's movements for a month. And it also suggests that it could be possible that a shorter duration would not violate one's reasonable expectation of privacy, but it doesn't say where the line is. It's just somewhere in there. Is it a day? Is it 2 weeks? Is it, don't know.
They turn it off and start it up again and let it sleep for...
Who knows? It's all open. It's all fair game. And so Alito basically concludes by saying, so, you just have to get a warrant because you don't know. And I think Alito is suggesting that perhaps Congress should maybe consider where to draw that line. So I think that the rule that comes out of that is that perhaps, okay, so perhaps there could be GPS tracking of some duration that might not violate the Fourth Amendment, according to Alito and the justices that joined him, but it's totally unclear what that would be.
So
and for sure a month would do it.
I have one more question, and I feel very strongly that if you transmit an email or Google Voice or Skype or do anything and you put data somewhere on Facebook and you don't know where that destination is or where that data goes, then you give up some, if not all, your privacy. I mean, you should have some expectation. Don't get me wrong. I'm just saying if you put things somewhere, they could be anywhere in the world, and they may not even be somewhere where there's any jurisdiction or any recourse. So I'm just kind of throwing that out there. Back to the mention about the cell phones. Your phone actually goes out and queries the towers. The towers don't so much query you. So when it comes down to tracking, is there anything you're aware of that's related to those? Because obviously the third party, the records, the phone records, we know they go back a long time, and they're able to be queried and presented really without your knowledge or consent, at any time. But as far as that tracking component goes between the towers, and not just cell phones, but mobile devices in general, has there been any distinction between actually tracking versus being tracked? Because again, your cell phone does actually go out and search for these things. It's not like the towers are tracking you per se. Does that make sense?
It makes sense, and we've actually made that argument unsuccessfully. But that was, for a while, there was, on the cell site tracking issue, we were not doing so well on the issue. But of late, we've had better success in convincing courts, and I think now with Jones, we have further ammunition. Going back to a point that Marcia made about how Jones didn't really, the third-party doctrine didn't come into play in Jones. Why Sotomayor brought it up is because she mentioned kind of, what we're talking about now, which is that the real tracking that the government is engaging in now is through cell phones. And which don't require physical intrusion or physical trespass. And so what she said was, that has traditionally been governed by the third-party doctrine, regardless of whether you have any choice in the matter. Like you said, you don't tell your phone, hey, communicate with every tower. It just does, and you're stuck with it. And she's called into question the basic principle that's always found that that type of government search is permissible. So that's something we're going to find in the future.
We're also loading apps on our phones and devices that give full consent to tracking in our favorite restaurants, where we get gas, what we do, where we go, when we go there, and I mean constantly. And it's not just advanced devices. I mean, there are some very basic phones that still embed these basic features. So, I mean, I don't see, I don't understand why there could be any expectation that
Well, and-
you would have privacy.
And that's what actually Justice Alito says in his opinion. He says, look, we have to re-examine the way people's expectation of privacy is changing. And like Marcia said, it's shrinking. And what Alito has, he has a really interesting comment where he says, perhaps people in society think that trade-off is worth it. You know, people want to check in that they're at some restaurant or they're with their friends. And, you know, everyone in this room, I think, is kind of smart enough to realize that, hey, maybe that's not such a good idea. But, you know, we're the minority, right? So we have to really be on the lookout for that. And that's something we're going to be fighting about in the future.
In 1 second, I think Steve has something he wants to say.
Oh, no, she had a question. I remember her hand was up. Good.
Sorry, that was my question. I was going to ask about the cell site tracking. So that was my question. He did it. Thank you. I appreciate it.
Well, the cell phone tracking litigation has just produced scores of decisions, mostly saying, the weight, I think, was starting to swing in favor of saying get a warrant, and my suspicion is in light of Jones, it may well continue. And there was the biggest decision so far out of the Third Circuit, if memory, Court of Appeals for Pennsylvania, primarily Pennsylvania, Delaware, and I can't remember if there's another state involved, but that aside, what the Third Circuit said, well, the magistrate judges had the discretion to require a warrant or not to require a warrant. They just sort of a Delphic opinion that has something for everybody. But my view is that Jones may change that landscape.
Should we do one more question? And then, of course, Hanny and I, we're going to be around, and so feel free to come talk to us at any point. You have one.
I'm curious, when you start talking about all the 20 document issues, if there's been any discussion of scope, because especially with the analogy that keeps getting thrown out about Facebook, there's not necessarily an expectation of individuals thinking they have privacy at all, as much as it is that they think it's private within a certain sphere.
Right.
Has that come up at all?
No, it really hasn't. There aren't really that many cases out there on this, right? It's not something that's really been litigated. And I agree with you. It's an interesting thing because it's not a situation where you think you are disclosing information to people and you think that's private. It's just that you think you know who gets that information. But of course, any one of those people could share that information with anybody else, right? And law enforcement does take advantage of Facebook at times. We've done a lot of Freedom of Information Act litigation around that to try to establish what exactly law enforcement's practices are with respect to monitoring one's activities on Facebook or what have you. And if you're interested in that, I would encourage you to visit our website. We have a number of blog posts and really interesting documents that kind of detail the practices. All right.
This is more about the majority opinion. So basically, could they get around the warrant by having somebody else, a informant, put it on the car?
Not if they're acting at the behest of the government.
So, like I said, Hanny and I are going to be around. Come talk to us with your questions. And thanks for coming. And thank you so much, Steve, for coming. That was totally awesome. It was fantastic.